I want to share my perspective on a situation where you're owed money from a company. The company goes into liquidation, liquidators are appointed, and they tell you there's unlikely to be any distribution to pay your debt. In this instance, it's worth looking at, did the director breach their duties in the way in which they traded the company? And a very simplistic way to look at it is, at the time your debt was incurred, did they already have unpaid debts prior to that period? And if the answer is yes, they were continuing to incur debts when they were insolvent, chances are your debt was incurred at a time where the company was unable to pay its debts, which can be a breach of director duties. Now, it's a bit more complicated. That's very simplistic analysis of that type of case. What we often do is then we would write a fairly educational letter to the director to say, look, here is the company situation. Here's how you traded the company. Here's some previous cases decided at court and how the court considers this type of trading. And it is a breach of duty. If it is a breach of duty, then you can be personally liable for the debts of the company and to make an offer. Ideally, you don't want to go through the whole high court process of pursuing a director for breaching their duties. But if you can use that process to get an early resolution and get 40, 50 cents in the dollar, that is probably a lot better than getting 0 cents out of a liquidator.